should go ahead and do that now while we're in between cases. To my right is Judge Carrie Evander, and to my left here is Judge Robertson from the Fourth Circuit, Associate Judge sitting with us today. So, all right.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
All right, next up we have another civil case, HEYLIN versus ANITA MUTTERS. And counsel for the appellant, you can proceed whenever you're ready.
Yes, Your Honor. For the record, Mr. Patrick Deese, I'm from Melbourne, and I represent Mr. HEYLIN in this appeal.
Okay. Please take your position at the podium, and how much time would you like for rebuttal?
I'd like 5 minutes for rebuttal.
Okay, you may proceed.
Good morning, Your Honor. This is an appeal of a case involving a parental liability for negligent tort of a minor. And the substance of it is controversial in the sense that there are different cases going both ways on it. But the procedure is what I'm really going to emphasize first, because I think that's the most important thing. In our initial brief, we said that the standard of review is de novo review, and we also said that the burden's on the party seeking summary judgment to establish the non-existence of material facts, and that the party opposing summary judgment is the party that's entitled to the benefit of the doubt in that regard. One of the first key points we raised was the summary judgment on count 2 by the trial judge. Count 2 was negligent supervision, was premature because discovery was not complete. In pages 12 and 13 of our brief,
Counsel, how long was this case pending in the lower court?
I think it was initially filed in 2010, Your Honor, but there was a prior appeal on coverage, and until that was completed, the case couldn't go forward, really.
You couldn't take depositions during that time?
I don't, Judge, it was, as far as I'm concerned, I believe the record shows that the case did not proceed forward because of the appeal of the coverage issue. So there was a prior appeal on the issue of coverage, but not on the issue of duty and liability.
But even assuming there's a prior appeal, how long did that take out of the 6 years?
I think it was 2.5 years, Judge.
Okay, so does the trial judge have discretion to deny a request for a continuance to take additional depositions if the case has been going on for 3.5 years and leaving out that 2.5 years, 3.5 years or more? Is that an abuse of discretion standard as far as the denial of a motion for continuance?
And we opposed that, and we filed a response in the trial court.
Right, but the burden of proof on that would be abuse of discretion, right, not de novo?
On the issue of summary judgment, or on
the issue of denying a continuance to conduct more discovery?
I would assume that's right, correct, Judge.
Okay, so are you arguing that the trial judge abused his discretion in this case when you have a complaint filed in 2010, and it's really not an overly complex case as far as, gathering the witnesses?
In response, Judge, the motion for summary judgment was not sworn to. The alleged affidavit in support of the motion was not an affidavit, but
but those are separate issues. On the denial of the motion for continuance, could the judge properly exercise his or her discretion and deny a continuance and proceed with the hearing, given the fact of the length of time and the nature of the case?
I think the plaintiff should have been given an opportunity to depose the witnesses that were revealed in the incident report from the Melbourne Police Department.
You had that back in probably 2010, right?
No, Judge. It was discovered. I believe it was discovered at the time we took the officers. We tried to take the officers' deposition.
As I understand it, the discovery you were seeking to take were witnesses or people present at the July 2009 domestic violence incident. Is that correct?
Correct, Your Honor.
What would you hope to gain out of that wasn't set forth and to be considered in your favor at the summary judgment hearing?
Number one, if you read the affidavit of Mrs. Mutters, She makes assertion after assertion that she was never present during any violence by her son. She didn't know about any violence. He had no propensity for violence. And in her opinion, this was all made up. And we asked her in deposition, compared her version of the deposition with the police reports, and she basically denied that the police reports were true. So we had a conflict of evidence with the testimony of her. In fact, there are so many I don't remembers, or I don't believe this is true, that I made a comment in our initial brief that she's incompetent as a witness, at least from the credibility point of view.
Is it your position that the police report is admissible evidence?
By itself, no, Your Honor. But the police officer who wrote the report is admissible.
Did you depose the police officer?
We tried to. We got through part of the deposition, but I think the opposing counsel made an objection, and I think that it was halted by opposing counsel.
And did you move to compel then?
Yes, Your Honor.
What happened there?
The motion wasn't heard, or the judge denied it. He granted summary judgment before we heard it. If I can go on to the other points, Judge?
When was the deposition of the police officer taken? How far before the summary judgment hearing?
I believe the summary judgment hearing, I have the chronology here, just a second, Judge. The deposition of Mrs. Mutters was taken on March 7, 2017, and there was the deposition was transcribed and filed on March 17, 2017. A verified motion for continuance of the hearing April 6, 2017 on defendant's motion for summary judgment as to count 2 negligent supervision.
When was the police officer deposed?
That's Jennifer Frost.
I'll tell you what, you can tell me that on the rebuttal, but let me ask you this. Assuming everything in the police report was true, do you think that's sufficient to avoid summary judgment?
In this case, Your Honor?
Yeah.
Well, if you want the easy answer or the hard answer, the easy answer.
So you want to give?
Okay, the easy answer is that the motion wasn't, since the motion didn't comply with Rule 1.510, the motion nor the affidavit is actually acknowledged, and the signature on the affidavit is not notarized.
All right, leaving aside the affidavit, because the affidavit would be disputed, if you would, by the
Right.
By the police report. Assuming everything in the police report is true, is that still sufficient for you to get the case to the jury?
And my answer, Judge, is if the witnesses, the police report and the witnesses contain a version of the facts that shows that the incident that happened to our client was a foreseeable incident.
Yeah, he'd broken up with his girlfriend, he got angry, he hit his mom, pushed her in the pool, hit a friend, he got arrested. Assuming that, and that happened 6 months before the injury to your client, if that's the extent of your case, would that be sufficient to avoid, or would that be sufficient to get the case to the jury?
Well, Judge, since we couldn't depose the witnesses that were present during that event, we didn't learn about the other instances, but there are other instances. In fact, the police report that was filed by the sheriff's deputy said that he interviewed 2 independent witnesses at the scene who both had been threatened with bodily harm by the minor who was the suspect in this case.
Did you depose those witnesses?
Did we depose those? No, Judge, we didn't.
Why not?
I think
That was going to be important for your case. Why didn't you try to depose those witnesses?
Well, first, I believe the deputy had taken I believe the testimony of the deputy was that he took affidavits from them, and that the affidavits were part of his report.
Yeah, but in your request to the trial judge to continue the case, you referenced the desire to depose the witnesses at the incident at the defendant's house.
That's correct, Judge. There was 4 people.
Did you mention your desire to depose these witnesses who were at the incident when your client was hurt?
We mentioned the minor, Mr. B.M. I'm not going to give his name, but the minor, Justin Culp, Dennis Miller, Mr. Gallard. These were, Mr. B.M. was the minor who was involved in this. The other 3 people were friends of his that knew him, who were present at this prior, I guess you might call it a prior incident involving.
Right, so did you tell the trial judge, and Judge, another reason I want a continuance is to depose the witnesses who were present when my client was injured, because a couple of them made a statement to the police officer, that he hits other people. Did you tell the trial judge that or make that argument?
The answer is no, Judge.
Okay.
As I read the record, the main incident you're relying on is the July 2009, I'll just call it the domestic incident that's the subject of the police report. Are there any other instances of violence that you're relying on that predate the incident with your client?
Your Honor, that's a good question. The police report that we have developed at the time of the depositions was this July 29th, I believe is the date of it. And that particular date was there was not only the incident with the mother, but there was an incident with 2 or 3 friends who were also present. So it's one way to say that this is one incident or it's 2 incidents, but arguably, Judge, it was more than one person that was injured by the minor at that time. And
so you were relying on that one date, though, just so we're clear. There wasn't another incident on another date. That you're saying that there were multiple incidents on that one date, July 28th or 29th.
Yes. And I believe
counsel, you've argued here, and you argued in your brief that the Mutters affidavit is deficient and not competent evidence because it doesn't comply with Rule 1.510. However, in your initial brief, that's where you stop. You don't explain how. You don't develop the argument at all. You make absolutely no argument as to how it fails to comply with the rule. And so, would you like to clarify that for us? And also, can we even consider it, given that you didn't develop it in the initial brief at all?
Okay, Your Honor, I believe that we brought that up on pages 12 and 13.
Yeah, I mean, you made the argument, but you just made a conclusory argument in one paragraph without telling us how the affidavit was deficient.
Well, I would defer to the deposition of Mrs. Mutters because it's clear in the deposition.
Well, counsel, is it this court's job to guess at what your argument is by looking at the deposition?
I would agree, Judge, but with the affidavit conflicted with her testimony. And if you want me to get the deposition.
Well, that's a conclusory statement. I mean, to make an argument in your initial brief, you need to not only say that it conflicted with something or it was deficient, but tell us how it was deficient. But you wholly failed to do that in the initial brief.
I can just tell you, Judge, I thought I devoted 2 pages to it, and if I apologize if I did not develop it. I would also point out this, Your Honor, that the paragraphs 12 on pages 12 and 13 of the initial brief talk about the record, and this record does not contain any what's called summary judgment evidence because there is no personal affidavit. The affidavit's not based on personal knowledge, and there is not a sworn to by Mrs. Mutters. And I put right in there that it was signed in Volusia County, and this incident happened in Brevard County. So there's a number of conflicts in the affidavit, in addition to the fact that her testimony in the deposition conflicts with her affidavit. So,
yeah, but as far as her affidavit, it doesn't matter where it's signed. I mean, I don't see where, if you had a witness who lives somewhere else and happened to be in Brevard County when the incident occurred and then went back home, it doesn't really matter where they sign it, as long as they're, subject to perjury charges, if you would. That's one of the purposes of the oath.
I brought a copy of the motion and the affidavit. The motion is not sworn to, the affidavit is not sworn to. It's an acknowledgement.
Well, the motion doesn't have to be sworn to, and the affidavit doesn't have to be signed in the county where the incident occurred.
Yeah, but it has to be sworn to, and it's acknowledged, not sworn. That's right on the last page is not, the notary says that it's acknowledged in Volusia County. However, this lady lives in Brevard County, and I don't understand. I pointed that out as one of the obvious conflicts.
Your theory of liability for holding the mother responsible is negligent supervision, and I think we're talking about the fourth exception under the Gisson case. Is that correct?
Substantively, yes.
Okay. And in Gisson, that requires that the child must be in the habit of doing the particular type of wrongful act which resulted in the injury complained of. How can that one incident, even if it involved multiple people, but that one incident in July 2009 constitute a habit?
And counsel, you're into your rebuttal time, just so you know. I mean, you can proceed, but I just wanted you to know you're into your rebuttal time now.
Sure. Thank you, Your Honor. The parents had custody of the minor. The minor has a special relationship with the parents. The parents have a duty to control the minor. The custody of the minor is the source of the duty. Excuse me, my mouth's still dry. So one incident I don't believe was one incident is documented in the court file, but I think there's two incidences that happened on the date I'm talking about, because it was not just the mother that was pushed in the pool, but two of the friends were struck in the face. So respectfully, Judge, I'll concede my time right now.
All right. And the counsel for appellee, whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is Cameron Shackelford, and I've had the pleasure of representing ANITA MUTTERS for the last 7 years. You just got a small taste of what the past 7 years has been like for me.
Well, Mr. Shackelford, let me ask you this. The passage of time certainly supports the trial judge's decision to deny the motion for continuance. But on the other hand, looking at the deposition of your client, you made objections of accident report, hearsay, juvenile records. I mean, is there any validity to any of those objections?
Your Honor, I believe there were, because
What's the validity to accident report?
I'm sorry?
What's the accident report objection?
Well, what I was referring to was the fact that Mr. Deese was trying to depose Officer Frost about a police report on a juvenile action. And these records are protected.
Well, the records may be protected, but the witnesses' observations of the events are not protected.
Well, even beyond that, isn't there a police report confidentiality provision that applies to such things? Because all the report is Officer Frost's observations, so they're considered hearsay. And the fact that it was...
hearsay is not a valid objection for deposition, because the question is whether it is admissible evidence or could lead to the discovery of admissible evidence.
Well, Your Honor, given the balance of the considerations, given the fact that we were dealing with a juvenile, I was trying to be very sensitive.
So you'd agree that even if the juvenile records are confidential, any witness's observation of the events involving the juvenile were not confidential. They could be testified to.
Yes, Your Honor, I admit that.
Yeah. All right, go ahead.
Mr. Deese indicated that the cases go both ways when he started his argument here. I don't believe the cases do both ways. I think the case law in this case is very clear, and I don't think the trial judge did anything wrong as far as applying the law to the facts of this case. Judge Robertson got to the point of this case when he mentioned the Gisson versus Goodwill, which we have relied on through the extent of this case. I think Judge Robertson's correct that Mr. HEYLIN was proceeding under the fourth exception to the Gisson rule, which says that a parent has to be shown to have some kind of knowledge that her child has a propensity for the kind of act that resulted in the injury that resulted. And we don't believe that anything Benjamin ever did leading up to this event with Mr. HEYLIN ever gave Mrs. Mutters, his mother, any sort of knowledge that he had a propensity for getting in fights with adults and striking them in the jaw. We admit that
Well, it certainly appears that there was at least some indication that your client was aware that her son had physically attacked in some way multiple people during at least that one date in July, right?
Yes, Your Honor. There was that one incident. Mrs. Mutters did actually arrive home after the violence, or as the violence was coming to an end, and Benjamin was leaving the home. She could certainly see the windows were broken. She could see mirrors were broken. She ended up in an altercation with him that ended up with her in the pool, and she knew that one of his friends cut his foot on some of the broken glass. But she never saw him actually strike anybody. And she testified in her affidavit and at her deposition. Mr. Deese had the opportunity to take her deposition, so all the conundrum about her affidavit, I think, should have been resolved at her deposition. But she indicated her deposition that she had never seen Benjamin strike anybody, and that this incident with Mr. HEYLIN was the first incident she'd ever learned about where her son had struck somebody. I think she also testified at her deposition that she did everything she could to control this child. She imposed a curfew on him. If he was late getting home from curfew, all he had to do was call her, and she would go pick him up. She testified to that at her deposition. So I don't think there's any way that this court can find under the Gisson test that Mrs. Mutters somehow had any kind of knowledge that her son was going to visit this injury upon Mr. HEYLIN. The court also asked about the trial judge abusing his discretion by denying the continuance. In this case, Your Honors, I don't believe the judge did, because the judge perceived that any testimony that was going to come from those depositions was only going to relate to the incident of July 2009. And I think he perceived that nothing that had gone on that night had been thoroughly fleshed through with the depositions of the officers and the police reports and the affidavits. There was nothing there that was going to call into question whether or not Mrs. Mutters had been given any knowledge that her son was going to strike people in the jaw. And if you recall, as the high courts, the appellate courts have worked on Gisson, the courts have made it clear that the notice has to be with a specific act that the child is being charged with. So you can't hold a parent responsible for their child striking someone in the jaw if they have past incidents of slamming a door and hurting someone's finger, or if they take a croquet mallet and hit a ball and hit a child with it. It has to be the specific act. So what these depositions would have had to do would have had to show that somehow Mrs. Mutters knew that her son had a propensity for getting into fistfights, and there was nothing about that incident of July 2009 that was going to impart that knowledge to her.
Well, given your client's spotty memory, shall we say, through her deposition, those depositions might certainly have been relevant to other instances of violence that the mother may have forgotten about.
Well, I guess if there were any other incidents.
If it's just for the July 2009 event, I understand the argument there. But if these people, and we don't know because those depositions weren't allowed, how would it change your analysis if they said, yeah, there were plenty of, he's been violent all the time and mom was there? I'm speculating because I don't know what they would have said because that depo never occurred.
You're right, Honor. That is speculation. I don't know what they would have said.
Well, assuming they would have said what Judge Robertson said they would have said, that there were a bunch of incidents and mothers saw it all. How does that apply to the analysis?
Well,
then?
let me go at it this way. If we took those depositions and those school-age friends of Benjamin's had in fact witnessed Mr. Mutters and other fistfights, how would that serve to show us what Mrs. Mutters knew? And that's the legally significant factor here.
Well, I think that was what Judge Robertson was saying, that not only did the incidents occur, that the witnesses might have said not only did the incidents occur, but mother saw it or knew about them. Right? So that would establish mother's knowledge of other incidents.
Well, that's
Different story, right?
That's pretty coincidental, but yes, Your Honor, that would be different.
When was the police report? When was that discovered? Just roughly, what was?
I think that was discovered fairly early on in the case.
You're not sure though.
I'm not sure though, Your Honor. It's been too many years. I know the police report came out in 2009, so it was certainly available for discovery. I'm just not sure. I know that we probably got it maybe before plaintiff's counsel discovered it. I don't know.
Was that incident alleged in the amended complaint? I mean, I guess we can check on that.
I would have to check the amended complaint before I could give you a certain answer on that, Your Honor. Now that I think about it, I don't believe it was. I think the amended complaint dealt strictly with the injury to Mr. HEYLIN. A couple final more points. Mr. Deese brought up the fact that Mrs. Mutters' affidavit was somehow insufficient evidence. I just want to make sure the court knew that he did have an opportunity to depose Mrs. Mutters, and even though her testimony wasn't that good, you have to realize the situation Mrs. Mutters was in, and if the court will oblige me on that, you have to remember Mrs. Mutters is an older widow.
She was undergoing cancer treatments at the time of her deposition.
Yes, Your Honor. She was undergoing cancer treatments. She has seen her youngest child arrested, prosecuted, and incarcerated by the state of Florida. Her husband was going through the early stages of dementia when this case started. She then buried him 2 years later. So she'd had a rough time, and she's got other things on her mind, and the deposition testimony was what it was. So to finish up, because I see my time is winding away, we believe the trial court correctly perceived what the standard is for holding Mrs. Mutters liable under the law, under the case law, and perceived that there was no way for Mr. HEYLIN to succeed on his complaint, and therefore gave Mrs. Mutters the summary judgment she sought. And with that, I will ask the court to affirm the summary judgment that was provided by the trial court, and I'll yield the balance of my time.
Thank you, counsel. Okay, counsel for the appellant, you have 3 minutes, 54 seconds.
Yes, Your Honor. I'd like to address the following. Number one, when was the police report discovered? It was at the time of the police officer's deposition, I believe. There was an objection. I'm sorry.
It was available in 2009, correct?
Yes, yes. But what I guess my point was the defense filed 3 motions for protective order the day we were trying to depose the police officer, and we were trying to depose Mrs. Mutters, and the judge signed 3 orders granting protective order on the 20th of September 16 without a hearing. So basically our depositions were actually nothing more than a proffer because we couldn't depose the witnesses. And
Did you raise that in your initial brief?
did I raise the fact that the...
Did you raise that as an argument in your initial?
I think we did, Judge, yes.
I don't remember seeing it. I'll go back and look.
Let me ask you this. You knew to seek the report. When were you aware of this, that a July incident had occurred, July 2009 incident had occurred? When were you aware of that? You filed a complaint saying, for negligent supervision against the mother, at least an amended complaint.
Right.
And so at that time you filed the amended complaint, were you aware of a July 2009 incident where the defendant had been violent?
Your Honor, if I can, let me just remember the date of the amended complaint. It looks like we filed two amended complaints, Judge. One was in August of 12, and the other was in June of 15. In the interim, there was an appeal on the issue of coverage. And...
Okay, but you alleged negligent supervision.
correct.
And did you allege prior knowledge by the mother of violent acts by the son?
I believe we did, Judge, if you want me to...
Okay, and so at the time you alleged that, were you aware of the July 2009 incident?
I think we were aware of it, Judge, when we filed the amended complaint, yes.
Which was in 2012?
2015.
Okay, how about the 2012 one?
There is an amended complaint on August 7, 2012, but I believe because the case was on appeal, there was nothing done at that point.
Right, but did you allege negligent supervision?
Yes, Your Honor.
And did you allege prior notice based on and being aware of the July 2009 incident?
I believe we did, Judge.
Okay, so there's at least 5 years that you were aware of the 2009 incident, and then, then the deposition scheduled, what, 5 years later?
Well, if you look at the record, Judge, you'll see that from the very beginning, this case was contested on two things. Number one, there was a contest that there was no coverage because it was a, quote, homeowner's policy.
Right.
And that was a decisive issue, and the appellate court, this court ruled on that there was a ambiguity in the policy regarding who was the insured, and therefore there was a...
But was there still a 5-year, at least a 5-year period between the time you knew about the July 2009 incident and the time you sought to depose the mother and the police officer?
Well, I just know there's two amended complaints in the court file, Judge.
Okay. All right, thank you.
Yes, Your Honor. You want me to continue, or?
So, well, let me ask you one final question that I know will go over your time. So I'm reviewing the transcript of, is it Officer Frost? And regardless of, you had the officer there, I understand there were issues administering the oath, and there were, whatever happened by the other side, but you had the officer there, and did you choose not to question her?
I think I asked her questions in a hypothetical form because opposing counsel was objecting and trying to get the judge on the phone to prevent me from taking the deposition.
But as I read it, you gave a long proffer of what you thought she would say, but I mean, you had the witness right there, and am I reading it correctly that you didn't question him?
I believe there was a prior order by Judge Harris for me not to question her. And I was trying to comply with that order and also make a record.
Okay.
Thank you, counsel.
Okay, thank you, Your Honor.